Oh, he's giving us.
Yes,
Wow.
please. Yes. I'll put it out one period. Sorry, I didn't know.
Yeah, but are they coming to you anyway?
Yeah.
Where are they?
Maria was Caspian. I invited. He's sending different kinds of requests.
Sorry.
They just yeah.
We do it smart. You're good.
I realised that plastic in the bin and that's there's a recycling into the I'll put it there like
Yes. Okay, no, okay. We made
She was an organizer.
we made a publication for the UN concession.
So good morning, everyone. It's 8:30 and we need to start because we have a busy schedule and we need to finish this side event in time. My name is Martin Stolsky. I'm from Arnica, NGO, and we are co-organizing this event with many colleagues from other countries and other organizations later. This site event has two parts. The first part is on implementation of the Aarhus Convention on the ground, and we will present alternative reports of the civil society organizations about the implementation of the convention, and also speak about challenges and obstacles, mainly because that's what NGOs really do. And the second part will be a discussion and presentation about the current problems of the Caspian Sea. So we will go a little bit different topic, but it will be also interesting. Thank you very much for coming. At the beginning, I would like to say you that if you are connecting through computers from here or online, then you should use your microphones. This meeting is being recorded. If you have like some objection against it, then tell us, and we will not use maybe some part of the recording later. And we have very limited time for questions and answers. We will try to give you some time for asking questions, but we will see how it will go. And you need to speak quite loud because there are some microphones in the room that are connected to the online participants. So in order to make them able to hear us. The chat in the Microsoft Teams is disabled. So if the online participants would like to ask any question, raise the hand. We'll hopefully see you, and they will give you a floor. So that's for the beginning, and I would like to give the space for initial presentation to Evie Andrushka, who is an expert who is with Aarhus Convention since the beginning and has a very big experience with the implementation of the convention. I would like to ask him for opening speech.
Thank you. Yes, I'm Jerzy Andruszka. I'm a member of the compliance committee since 2006, the longest serving one. And now currently the vice chair of the compliance committee of the Aarhus Convention. And I was asked to give a couple of introduction words about
Please mute the microphones. Okay. Sorry.
I continue.
Yeah.
And I was asked to tell you what is the way that the compliance committee look at the implementation reports and this alternative, or you originally called them shadow reports, and that is the nickname that we usually use for shadow reports. That are the ones that are alternative reports produced by the civil society, usually very critical about the official implementation reports. So in order to be brief, just a couple of remarks. First of all, Aarhus Compliance Committee is different from the standard compliance mechanism in other environmental agreements. For this other environmental agreement, key is the national implementation report. So this is the soul of the compliance mechanism. Apart from this, there are these bodies, and these bodies, differently called implementation committees, compliance committees, look at these reports submitted once in a while by the parties, governments, in order to see whether they comply with the requirements of the convention. But this was invented for the purpose of other environmental agreements, which were much more technical. So that was of utmost importance whether these reports reported proper reduction of emissions, or this kind of stuff. So that was very technical in the sense. However, the Aarhus Convention is different. And also for this traditional implementation of compliance mechanisms in other environmental agreements, the composition of the committee was different because they were composed of the representatives of the parties, that is, representatives of the governments. And I was a member of such a committee on the ESPO Convention. You all know ESPO is about transboundary impact assessment. And this is a pretty much traditional mechanism in which members of the implementation committee represent their countries. This is not the case in Aarhus Convention, where members of the compliance committee are meant to not represent the country. They are actually forbidden to represent the interests of the country. They are supposed to be independent. And this was modeled after the human rights bodies. Therefore, and even more at its origin, in the course of development of the compliance committee, it was much more behaving like a court of law. Therefore, it is reacting concrete cases. We have a communication, there is a possibility for everyone to submit a communication, and the compliance committees as a court is reacting to the case. So now coming to the main issue. The national implementation reports by the parties are still obligation, but in fact, the Aarhus Compliance Committee, regretfully, it does not look into them much. That means also the role of these alternative reports is slightly different because they also are not regularly used by the compliance committee. However, it is very important that the same information that is there, instead of having a horizontal overview of the compliance with the Aarhus Convention, it provides concrete facts that could be used for a concrete case. In such a way, the compliance committee sometimes may use this, both the implementation reports or these alternative reports, in handling a concrete case. But despite the efforts. The compliance committee is overloaded with concrete cases, and it is not simply able to address generally the issues. And secondly, you also should be aware that these national implementation reports are produced by countries in the way as they interpret the convention. Therefore, sometimes they interpret it wrongly, and they do not look at certain key issues. Like, for example, for ages, for the countries of former Soviet Union, so-called ECA countries, Eastern Europe, Caucasus, and Central Asia, they didn't realize the biggest problem with the former expertisa system, or VOS expertisa system, in which the developer was responsible for public participation, which was one of the major problems with meeting the requirements of the Aarhus and also ESPO conventions. But simply, they didn't realize this. And also, quite often, the shadow reports or alternative reports didn't notice this. You must be aware that both the national reports and shadow reports, with the ambit to cover horizontally all the issues related to compliance with the Aarhus Convention, may not be so specific to detect specific non-compliance issues, and that therefore the compliance committee is not so often using these both reports in their day-to-day life. So my call is that it would be useful to make them very detailed, look at the cases where there was already the non-compliance, and specifically so-called follow-up, and checking in the alternative reports whether properly done the recommendations that were produced and introduced into the meeting of the parties' decisions, whether they are being followed by concrete governments. And that is not always the case, but these follow-up procedures are nowadays, in addition to these new communications, it is more and more something that the compliance committee is looking at, and that could be very useful, this shadow report, in assessing the follow-up, the recommendations or the implementation of the recommendations. So that's all from me for now. Thank you.
Thank you very much for valuable insight. I guess that this is a very important suggestion for us as NGOs, how to prepare these shadow reports for the next period of the Aarhus Convention. That's something that we should take into account. And now we will briefly introduce some of the shadow reports that were produced to cover the period of the last 4 years. We will start with Belarus by alphabetical order. Belarus is a little bit untypical case because that is the country that withdrew from the Aarhus Convention, and that case was very much related to persecution of environmental activists and to NGO EcoHome that was lately banned by the law. And we have here Sergei Mahnov, who is an independent lawyer, who will a little bit also update us about work of EcoHome and also tell us how is the life in Belarus without the Aarhus Convention for the last few years.
Yeah, thank you, Martin. Good morning, dear colleagues. Does the life exist after the Aarhus? It's a kind of question. And as Martin mentioned, Belarus was withdrawn from the Aarhus Convention, and one of the reasons was the persecution of EcoHome NGO and other cases of persecution, and the country was not agreed with measures taken to it and sanctions. So it was declared that it will withdraw from the convention and done it finally. So now we have some Aarhus heritage, which we still use in Belarus. For example, it's not the worst legislation. It's a lot of tools for exercising environmental rights, some provisions concerning access to environmental information, some issues on public participation, but it's not the best one, as Dr. Indroshka mentioned that OWASP expertise system is not the best way for, but due to low public involvement in such cases, so it's for Belarus. It's now I would say it's a good example because despite the persecution, public still interested in environmental issues and participation in decision making, but this participation is very low now, and some losses are concerned with withdrawal from the convention. It's a country. First of all, it's a reputation and international image of country, but you know, a few years later, some behavior of Belarus was done much worse for its reputation, not only withdrawing from the international conventions. And also, a country lost participation in international development programs, and the most losses is for public. It was an opportunity to implement best practices in our practice and legislation, and the public lost an opportunity tools of Aarhus Convention, compliance mechanism, and now rapid response mechanism, so special rapporteur to protect environmental defenders and to exercise other rights. But now current situation is it looks like that national legislation still have provisions for access to information and access to justice, for public participation, but generally public scared to run any activity due to persecutions of any public activity not authorized by authorities. And there is no NGOs registered left in Belarus, so it's quite difficult to provide assistance, legal assistance, or consultations for general public. And most of NGOs' resources, like web pages or social media pages, are declared as extremist materials. So using or sharing, for example, a link of these materials will be punishable. And we can go to the last one. And it's one of interesting issues from the last year. Despite the fact that Belarus is no more part of Aarhus Convention, some of compliance committee findings are still implemented in new legislation changes. For example, access to information and the opportunity to appeal to the court in the cases of previously it was an opportunity to appeal only somebody denied access to information, but in the case of non-properly providing the information, that was not direct opportunity to appeal to the court, but now it's such provisions was implemented in the national legislation.
Thank you very much. So there is at least some positive legacy of the harvesting, and Belarus still living. Now we will look at the situation in Bosnia and Herzegovina and ask Dr. Filipovic, who represents the Center for Environment from the Center of Bosnia and Herzegovina, to tell us the situation in the country.
Thank you. I will be quick as I could. So this is our shadow report, and you can go to the next slide. Its content is that it exists in analysis of questionnaires. We sent about 58 questionnaires and received 38. Questionnaires were sent to all the parties. The next is examples from practice. We have 2 cases of each pillar and 1 criminal charge. No, go back. Go. In this report is also PRTR protocol. There is a progress, but you will hear more on side event. Of course, persecution of the activists. There are some cases of persecution, more side event. We have 2 cases to write to Aarhus Convention Compliance Committee. And of course, conclusions and recommendations. The next. This is our 4th report. That is follow national reports. We use reporting methodology like I said, we send the questionnaires. We have case studies, 7 cases. We have practice examples. We send, we communicate with the institutions from the different administrative levels in PH. Bosnia and Herzegovina is very complicated administrative country. We have communication with the institution with different competencies, ministries and their administrative organizations, public institutions, courts, and local government departments. And we also dealing with the organizations who are dealing with the environment through EcoBih. It's a network around 40 organizations in Bosnia and Aarhus centers in Bosnia. Regarding questionnaires analysis, we have some conclusions. Of course, the much more you can read in the report. So we find out that there is a certain number of the cases of the administrative silence still. They are not response to our request for the informations. There are exceptions of the providing of the information in projects declaring by authorities to be of the public interests. These projects are protecting the private companies. These companies are Chinese or Russian. The number of initiated procedures in the field of the environment is an indicator of the interest of the private and domestic legal entities and the use of natural resources. The number of the judgments in the administrative dispute regarding access to information is an indicator that there are procedures in which information is accepted from disclosure and it's of public interest. The number of the proceedings initiated before the court is various disputes show the investment of the increased effort of our Aarhus centers in PH. We have 5 Aarhus centers. Increased involvement of citizens in the adoption of the special planning documents. There is no increase in the send and answer request for the access to information compared to the previous period. So we have some progress, but this progress is still not enough. We have concluded that there is a progress in application of provision of the Aarhus Convention. There is also information excluded from the public in the projects of public interest. There is constant need for the educations of the officials and the representatives of the civil sectors. There is increased interest of local communities in environment subjects, and there is maximum utilization of domestic and foreign legal mechanisms. We don't have a database. I don't know if it's necessary or not in the world level, Europe level, but I think it's necessary to have a database. There is no insufficient understanding by all authorities of the role of the Aarhus Convention in the development of the democratic societies. There is no intensified cooperation between CEOs organizations dealing with the environment and authorities, and there is no implementations VRTR still in full capacity. We have some recommendations, and first of the recommendations that is needed for like 20 years is education of the employees in executive authorities in the application of the Aarhus Convention, creation and distribution of the guide for the access of information, in particular process of the test of the public interest. This is something that authority use in their own way, not to give us an information. So it is needed to be clear, this procedure about public interest, intensive cooperation between civil society, inspections, and the executive authorities with the active participation of focal point of BH. We have some cooperations, but when we point some problem, all the authorities said it is all by the inspections. Design and creating uniform database, it's also needed. Return to the competence of the organization of the public hearing to the public authorities, because now the investors is organizing the public hearings, and court procedure under the provision of the Aarhus Convention should be originator putting the PRT protocol into the full operation.
Thank you very much. So we heard a lot from this report. You can download all the reports that were produced for this period by QR code that are located on the board over there. So if you're interested to read more, you can find the reports. Now I would like to ask Lisa Schneider to tell us some comments to the national implementation reports of Germany. She's representing Independent Institute on Environmental Issues. So,
thank you very much, and good morning. I will present the comment on the national implementation report of Germany that was drafted not only by us at UFO, but together with several big German NGOs. And there are also slides, I think so.
Yeah, I'm trying to find them.
Yeah, perfect. You can skip to the following. So in spring 2025, in spring of this year, the Federal Ministry of Environment gave the public 6 weeks to draft report for the national implementation, and our comment was made during this public participation procedure. So you can also see that the date it's already written in April. I will come back to that later. You can skip to the so I just will briefly run through some points that we came across when we drafted the report. So first of all, the report is mostly a list of activities undertaken by the federal government, and we obviously welcome that there are many relevant activities in Germany that implement the convention, but we would have liked a more systematic analysis in the implementation report, and the report as such is quite difficult to navigate. There's, for example, no table of contents or something that is for people to understand what the report is actually about. And there are often references to older reports without mentioning the content or the reference. And sometimes only very specific activities are mentioned, sometimes only legal regulations are mentioned. For example, with regard to environmental defenders, so implementation of Article 3.8, there's mentioning of the implementation of the anti-SLAPP directive, but without mentioning, for example, the actual difficulties that environmental defenders are facing in Germany, so nothing about what is actually happening on the ground. And also, Germany is a federal state, so for example, education is in the competence of the 16 Länder, or also access to information that the Länder hold. They have on regional level laws, and that is very fragmented information on that in the report. Yeah, and then the report as such is at points somehow contradictory. So, for example, at one point it claims that Article 3.4 of the convention is implemented sufficiently. So this is about how environmental associations are recognized in the legal system. But there are findings by the compliance committee that this is actually not the case. So at another place in the report, when it talks about Article 9, there it is mentioned that there are these ACC findings that have to be implemented into German law. So yeah, we have seen some contradiction in the report, yeah. So and then I think we have a very important point that is missing completely in the report. So there's nothing said about the legislation for accelerated permitting and the fragmentation of rules on public participation. So we cannot see that. And yeah, of course, also a general problem with Article 8. We heard about that yesterday already, that also the German government sees it not applicable to legislation. And digitization in general is not really mentioned. And this is also especially in access to information and public participation changes a lot. Yeah, so here, that was more of the content, and now I will say something about more of the procedure of how we came to write this report. So yeah, 1 month after the reception of our comments, the final report was published on the website of the Ministry for Environment. And yeah, in the final version, the comments we made were not included or discussed with regards to content. But we have this paragraph here that was included in the report that states that there has been public participation, and that also alludes to our comment that was also uploaded on the website of the ministry. And yeah, so we were now thinking that for us it would have been preferable to take our time until MOP to just do our own report. And comment on the report that was made by the by the ministry. Of course, the report was also had to be not only agreed upon by the ministry itself, but by all ministries in Germany. So of course we know that it's not easy to find an understanding there. But yeah, we would have preferred to maybe would put our resources not into this public participation procedure, but into drafting just our own report, because of course for us also resources are a problem, and we don't really have funding for this kind of work. So yeah.
Thank you very much. Now we will look at the situation in Georgia. The shadow report of Georgia is named Access listed. Each team already indicates that there are some serious problems in Georgia. We would like to hear more from Salome Shubladze from Social Justice Center.
Please, please go ahead. Okay, good morning, everyone. As Mark mentioned, I'm Salome, and I represent Social Justice Center. This is basically human rights organization working in Georgia, but we have been also working on the environmental procedural rights, and more importantly, on the rights of local communities affected by different environmental decisions for years now, I can say. But unfortunately, maybe as you are aware, our work is also under serious threat because, for example, our organization's accounts are frozen at the moment, and this happened in the the framework of the ongoing investigation on sabotage charges. And this investigation targets not only our organization, but also 10 other civil society organizations. And this is, politicized investigation totally, but the grounds, legal or factual, of this investigation are just nonsensical. For example, our director was questioned about her social media posts pertaining to the protests and her criticism of the government. So, of course, we see this as the criminalization, protected expression that is definitely under freedom of expression and is, of course, completely peaceful. But this is not a new thing for us. And I would like to mention that for our work on environmental issues, we have already been targeted by the government. For example, our organization was not named by the name, but we were mentioned in the State Security Services report, which was about this Namahwani HPP case and the resistance to this large-scale dam, in which we had our part in terms of legal support of the local community that resisted to the project. And as I mentioned this because it shows how government sees environmental protest, environmental resistance. It sees it through security lens naturally, and it then continued its narrative about these foreign agents damaging, jeopardizing the energy security of the nation or the national interests of the country. So this, of course, then continued, and they even, as you know, adopted foreign agents law. But I just wanted to highlight that these labels were used against environmental activism and environmental organizations even before this shift to our consolidation that we are observing at the moment. As for our shadow report, I would like to say like few basic words about the pillars of the convention and what is the situation in Georgia in terms of, first, access to environmental information, right? So this is again very problematic because, for example, just to give you some statistics, approximately 58% of the public information requests that are submitted are not answered by the governmental agencies at all. Only 33% are satisfactorily answered, and others, they are denied, or they may be the time frame is longer than allowed by the legislation. As for the specifically environmental information, the biggest problems that we face in Georgia is that government faces environmental information as commercial secret, oftentimes, and the information about, for example, contractual terms or even general conditions of the concession or investment agreements that they form with foreign investors, like primarily those information, those kind of documents are like fully closed as commercial secrets, and there are no attempts to maybe disclose some and say that some parts are commercial information. Even at the moment, we have a big public controversy around this Arab investment now that is envisages the building of huge development projects in the forest area in Tbilisi and also in Gonio, and government is saying that this contract is fully secret and we have no right to have access to it and to have the information about the scope of the agreement, the concessions government made, what does it envisage in terms of environmental impact as well, because at this stage, all the information is closed. So this is one of the biggest problems in terms of access to public information. As for the public participation in decision-making processes, I would like to outline main trends. So we have environmental impact assessment code, and some activities fall under this under the coverage of this code. But the problem is that many decisions are made before any public hearing is held, or then the problem is that some of the decisions are not even subject to any kind of public hearing. For example, let's say the development of energy projects. Again, the contracts are concluded and the main decisions and the scope of the project is outlined well before the public hearing. So public is not engaged in early stages of the project development. So it affects, of course, their opportunity to make impact and to affect the final decision. And again, there are decisions like, for example, the picture you can see at the slides, it's the Balda Canyon. This is protected territory, natural monument that government decided to lease out basically to private company without any consultation or even informing the local community that lives just like next door of this protected area. And it was very important for them culturally, spiritually, or otherwise, but they were completely excluded from this process. And only after the construction started, they found out that there is some kind of project planned there, and the government did not inform them in any way. So just being mindful of time constraints, just to sum up on public participation, yes, it is very problematic because, again, decisions that very directly affect local communities are made without them they're informing. And this problem is also in the sphere of mining, which is, you know, very it has huge effects on the population, and even mining decisions are not made with the consultation with the local population. And of course, this picture again is from the same community, basically the community that lives near Balda Canyon. This is the picture from our court hearing. You can see our lawyer there as well. And I put this picture here because for these people, court is something that is very important. So they always try to go to attend the court hearings because they feel that at least court can hear their concerns and remedy whatever like government did wrong. But unfortunately, so they had to wait 9 months before single hearing got scheduled at the court, and then court denied our submission for interim measure, basically the injunction that would require from the government to stop all works until court hearing would be concluded. And this is a trend because we had up to 20 cases for like these years, and our submissions were never granted for interim hearings. And again, in terms of timeline, this case is not an exception. We have had, at the moment, we have seven cases pertaining environmental issues, and we had not had a single hearing scheduled for those cases more than 3 years. So this is trend in Georgia. If the case is about some sensitive environmental issues that involves corporate or political interests, of course, the courts refuse to properly hear the case. Maybe I'll stop here, and thank you very much for your attention.
Thank you very much. I'm sorry because our time is really short, so
Sorry.
I would like to ask all the presenters to keep within 5 minutes now, because otherwise we will not have time for Caspian Sea, which will also be very brief. So we will now hear very brief comments to the National Implementation Report of Kazakhstan from Zuzana Vakhudova, who will represent the Green Salvation based in Almaty.
Okay, thank you, Martin. So I'm actually from the Arnica Association, and I was asked to talk on behalf of our colleague from Kazakhstan because unfortunately they cannot be present here. As Martin said, the Ecological Society Green Salvation, which has been operating for more than 50 years, prepared comments to the National Implementation Report of the Republic of Kazakhstan. You can go on further. So I'm just going to briefly mention their findings or their comments. So in regards to the access to information, the situation remains challenging. The national report itself actually doesn't provide any statistic on the provision of environmental information to the public. But according to the Ecological Society own inquiries, approximately in half of the cases, the information that they obtain from government agencies are inaccurate or incomplete. And inaccurate information is also provided in the report itself, where it is stated that the right of citizens favorable environment is enshrined in the Constitution of the Republic of Kazakhstan, which is actually not true because what is really written in the Constitution is that the state aims to protect an environment. So there is a clear difference between right for the environment and the aim to protect the environment, which is much less strong phrasing. And the Ecological Society actually a lawsuit in connection with this, with the fact that the Ministry of Ecology and Natural Resources provided false information to the Aarhus Convention bodies. That's just one example of cases they are dealing with. I can go further. When it comes to public participation, again, the principles of the conventions are not fully implemented. Citizens typically learn very late about the project. Only implementation phases when it's not possible to get really involved. Public hearings are not required for all projects, and there is also not a clear method how to actually take public opinion into account. And in 2021, there was exclusion of the mandatory AIA procedure for all types of economic and other activities that obviously limited the public participation significantly and had really strong impact on some projects planned in the national parks, especially and in protected, especially protected areas. That's one of the example of what is happening in one national park, in Alatau National Park. In regards to access to justice, again, it's not fully implemented. There are constant changes in legislation that create new and additional barriers to access to justice. In 2021, there was an introduction to the Administrative Procedure Code that really limited access to justice for people, including extended periods for the courts. One of the problem is also that the judges and representatives of executive authorities allow arbitrary interpretation of law. And on the photo, you actually see like a very typical example when the decision of the Supreme Court actually remains unimplemented for 12 years. So it is highlighted to me that this is not an exception, but rather a rule that decisions really takes years to be implemented or remain unimplemented. So I think I'm exhausting all the time. So just to summarize, here is the list of, let's say, a list of reasons why the Republic of Kazakhstan doesn't comply with the Aarhus Convention, including low level rule of law in the country and high level of corruption. And you can see also that they mention increased exploitation and pressure on exploitation of natural resources. I think this is something what we are experiencing in many other countries as well. And I will finish here. If you had any questions, I'm happy to take notes and connect you with the authors.
Okay, thank you very much. Now we will go to Moldova and we will hear if Aarhus Convention is still an instrument for one democracy from Ilya Trombitsky from Association of River Keepers.
Thank you. I will stop only on main challenges and recommendations. In general, situation in Moldova is, in my view, is not bad comparing with other countries of the former Soviet Union. So it's no any pressure to NGOs. Also, last years it was a substantial progress in democratic changes. At the same time, there is we observed too much politics in issues which are not in general are politically. The case which we have now in the compliance committee, in my view, is related mostly to the weak attention of the ministry towards the subordinated agencies. And these agencies like to create some business with the information. At the same time, exists general understanding that we should follow the Aarhus Convention. Unfortunately, because of this weak attention, we did not reach much progress in current case. At the same time, because of long time of captured state, it remains some consequences like dependence of courts from the from the government. Also, government sometimes is trying to press judges in favor of decisions, political decisions. We had last years the vetting and pre-vetting procedures for judges, prosecutors, etc., which also was not, in my view, very efficient. So the quality of judges did not change substantially. Judges understand that they should decide as government likes. We had one party, or one ruling party, and still have one ruling party, which is officially pro-European, but at the same time, they use this monopoly on power for some anti-democratic decisions. Like, for example, immediately after invasion of Russia to Ukraine, it was introduced emergency situation. And during 2.5 years, at least, practically government used this situation to limit rights of people, including in the environmental sphere, also some securitization of information, etc. And at the same time, because of fast change of ministers, the last national report was prepared in 2018. And after that, it was prepared one yearly reports, which are not enough complex. Next one, please. Oh, sorry, return, please. I understood. Yes. And we observed also some pessimism among civil society towards possibilities of public participation. That is why activity of NGOs is enough low. And we observed that, for example, on public hearings on the national report came only 2 or 3 maximum NGOs, including those who created this report. That means because of lack or weak capacities of government, some NGOs help to create national reports when others create alternative reports. And because of that, of course, government do not feel responsibility for what is happening. I mean, ministry. We have also, because of these great changes in the judicial system, some cases, length of some cases in the court have up to 7 years, which is totally not efficient. Also, a very weak number or a small number of experts, and it is also not created good conditions for assessment and as I said, we lost a lot of judges. Some of them were corrupted, some politically not good for government, but anyway, it was during this period introduced court fees. They are not big, but anyway, it is obstacle for public benefit interest cases resolution by NGOs and other interesting persons. And in general, limited exceptions for environmental judges cases concerning these exemptions, and no public trust in judiciary and enforcement delays, and this is a general situation. And we recommend adoption of National Action Plan. It was going starting from 2011, but one plan was adopted, but nothing was done. Mikhail Tsesha should confirm. Align legislation with EU and Aarhus requirements. This process is going by enough week. Improve access to data. We have a very limited data in internet, unfortunately, despite such files exist. Also, institutional capacities should be built. It's necessary to promote open data and transparency through integrated online portals. They are now exist, but mostly in theory. And Aarhus implementation national report should analyze not only the legislation but its implementation, because in our national report currently is mostly written that what is written in legislation, everything is fine. When we look what is happening, nothing is happening. This is a real situation, and thank you.
Thank you very much. We have last 5 minutes for the last presentation from Ukraine. So I would like to ask Olha Zabramna-Melen from Environmental People Law from Lviv to tell us what is happening in the country.
Good morning. Thank you for inviting and for interest in this topic. I would like to bring a perspective from Ukraine, who prepared this report, who prepared its national implementation report during war time. Actually, our previous report from Ukraine national implementation report was missing, but luckily for this period, the Ukraine prepared national implementation report, and our organization reviewed it, and we also have our own suggestion and our own opinion what was happening good in this terrible period for our country when we were striving for our lives and for independence. But during this time, there were some positive and negative changes. So I will draw attention first to the access to environmental information as the first pillar of Aarhus Convention. It's worth saying that this was the period during the reporting period we are discussing. This was the period of total digitalization in the country, and not only in the environmental ministry, but in many other agencies. As a result of this trend to digitalization, we received a big platform for access to environmental information, which is called Ecosystem, and it contains near 37 registers, including EIA registers, register of strategic environmental assessment, PRTR register of different kind of permits in the field of air pollution, waste management, and other. This register is the positive trend. We only want to mention that the access to this register is limited, and the authorization is needed. You have to have your own electronic signature to access to this register. So we believe that this is not a very open and accessible tool for many, as many members of the public, general public, are not do not have electronic signature, cannot access this register. But for those who have, it's a really very useful tool. Okay, public participation. During wartime, there were attempts, to limit the environmental impact assessment procedure because it turned out to be quite effective, and public used it a lot. So there were attempts and some official attempts to exempt some recovery works from EIA, the works on mitigation of consequences of accidents, and to exempt from EIA also the business related to production of explosives was exempted from environmental impact assessment. And also there were discussion, and Parliament made a decision to decrease the duration of public consultation during environmental impact assessment. And also during that time, there were numerous attempts, to exempt some projects from environmental impact assessment. Forest agency were always lobbying to exempt logging from environmental impact assessment, but luckily unsuccessfully. Till now. Also, we received a new register of environmental impact assessment, new register of strategic environmental assessment, and they are really quite a good and progressive tools, and we use them a lot. Now, also, Ukraine introduced new law on IPPC, introducing integrated environmental permit, and it has wide provisions on public participation, but it just was introduced last year. There was quite a good law on public consultation introduced, but it's not enforced. The problem is that many laws which are introduced in Ukraine related to environmental protection or public participation, they are not. They have a clause that they will enter into force after the war will be over. So that's why some environmental reforms are delayed during this martial law. And concerning access to justice, not many changes were happening. The courts were functioning during wartime. Parties were allowed to participate in court hearings during video conferencing. We have a very good comprehensive system of electronic courts. We can access all files of the case electronically. We can file a court suit electronically. We can participate electronically. But there are some still problems remaining the problems, as was mentioned by previous participants, as the length of the court proceedings, and also no interim measures usually are applied in environmental cases. Our organization asked for interim measures a couple of times for injunction, and it's a pity our courts are really quite afraid, to take those measures. Also, what is possible that Ukraine ratified GMO amendment, and this was a crucial step for its amendment to enter into force. So, in general, saying that during martial law we have some difficulties in implementation of Aarhus Convention, but in general the country is doing some positive steps, and those steps are really guided by the need to approximate environmental, to approximate to the EU and to approximate EU legislation, EU directives. So for Ukraine, it's a really serious impetus to implement Aarhus Convention better through approximation to EU legislation. Thank you very much.
Thank you very much. It's quite impressive to hear that Ukraine is still managing to protect the environment at the time of war and also to open some space for public participation. So thank you very much for that. We do not unfortunately have any time for any questions at this moment, but we will see what time will be finished. Maybe we can put some at the very end. But now we are going to the discussion about the Caspian Sea and triple crisis.
Thank you very much, Martin. My name is Dina. I'm a communication specialist for the Civil Caspian Sea company. I'm really grateful for this opportunity to be able to talk about the region of Indian Sea. Even though what's happening there tells us a lot about the global environmental crisis we all share. You can see this one. So first of all, I'm going to just to introduce you to the Caspian Sea region, to the problem we are facing there, and then I'll talk about the movement a little bit more. So as you all probably know, Caspian Sea is the largest enclosed body of water and covering about 370 square kilometers, which is larger than Germany. It lies about 28 meters below the sea level, and it's nestled between 5 countries such as Azerbaijan, Iran, Kazakhstan, Russia, and Afghanistan. You can see what actually remains of it is not just a regional issue, it's actually a mineral of different environmental issues, which are rooted in climate change, extractivism, and political opacity, all condensed into one shrinking body of water. So the problems that the Caspian is facing, well, it's basically a triple global crisis. It includes obviously climate change, because with low Volga River rising temperature, the sea could actually drop by up to 18 meters by the end of the century. Another problem that the Caspian Sea, the other problem the Caspian Sea is facing is the biodiversity loss. Actually, the populations of sturgeons and seals, which the Caspian is famous for, have declined by over 90% already, which is awful, and it just continues this way. Another thing that I wanted to highlight that, well, another problem happening there is that over 2,000 seals were found dead in November of 2022 again, and just like the numbers going up. And the third problem of the Caspian Sea is pollution. It comes from oil and gas operations. And obviously all the plastics and oil waste just keeps accumulating there, and the sea cannot just flush itself out. So it just stuck there. This is the environmental situation we're dealing with there. And now let me just talk about our movement a little bit more. So it's a fairly new movement. It was founded in last year, at the end of last year, in December of 2024. And it actually brings together experts, activists, creative professionals, and concerned people. There are three main pillars that guide everything that we do. We're all driven by the same message that the crisis is real, and it requires transparency and accountability and action to be able to overcome this issue. And this is exactly why we're here today, and that's why we think it's important to talk about it. Our movement brings together experts, activists, and people from different fields, because we are all united by three main objectives. Those are, well, first of all, obviously, we wanted to raise awareness about the issue. And probably one of the main goals that we have is to hold corporations accountable. And the team who's going to present after me is going to elaborate much more on this. Another objective that we have is to advocate for stronger policies and mobilize support. And in order to deliver on these goals, we focus on three main objectives, which are accountability, pushing for stronger oversight, we're resorting to legal tools, and yeah, Vadim is going to talk much more on this. Transparency is another big thing for us, because we are trying to raise awareness about the issue using different tools, media, social media, and also offline events. Which is a perfect segue to the next direction of our actions, which is action. We wanted to engage people on the ground and online through, again, different kind of tools, events, all those things. At the time of, as I mentioned, the campaign was founded at the end of last year, in December of 2024, and the context we're operating in is very important to mention as well, because the political landscape around around the Caspian Sea has been changing quite drastically. But there are a few things that I wanted to highlight in particular, which were quite helpful in terms of the timing for the direction of our campaign and all the activities. Also, first of all, like a month in January of 2024, President of Kazakhstan, Kassym-Jomart Tokayev, he called for a revision of public sharing agreements. Another important point that Vadim is going to talk about more. Then in April of 2025, there was a huge media investigation produced by ICIJ, which is an investigative journalist, who revealed some interesting findings about a classified $160 billion arbitration case between the government of Kazakhstan and NCOC. And then one of the latest updates is that at the end of September, President of Kazakhstan, he called for an interstate program and even a new regional center for water issues. So this is the context we're operating in. And in terms of what we have been able to achieve, as I said, like one of the pillars of our activities is transparency. And one particular event that I want to highlight to you is that in April of 2025, there was a trial on gas acquisition in Kazakhstan, and we attended it, and one of our team members, she actually questioned oil and gas representative about their environmental monitoring compliance. Obviously, we didn't get any response, but at least we were able to get that on camera. So there's proof of the fact that they didn't have any response prepared, and we were there, we were willing to engage in a conversation, but that didn't happen. Again, not very surprising, but that was one of the things that we've been able to achieve. Another thing that I wanted to highlight is one of our latest events. As I said, we've been trying to engage into this conversation in creative ways. We're trying to get public's attention. It's really important to reach people beyond the regular circles of people who care about the issue. So we organized a performance in Aktau, which was called SOS Save Our Sea. And the idea was to show two different possible scenarios for the Caspian Sea. One where collapse continues, And the other one is during the future where ecosystems and communities can actually thrive. So the idea was for our message to resonate with the general public in a more creative and powerful way. But of course, raising awareness is not enough. We also need solutions. So yeah, so I'm gonna skip this slide. I just wanted to show like a few examples of how we've been trying to communicate on this issue very broadly in media. We have been able to achieve media coverage of this story in like different languages, in Polish, Italian, English, Russian, Kazakh, and many others. But again, as I said, awareness is not enough. So we need solutions, and that's why we developed this practical 10-step roadmap outlining actions that governments, companies, and like international partners can take from real-time environmental monitoring to citizen participation in the just transition for affected communities. Because well, the Caspian Sea is a turning point, and that's why it's important to start active now. And for us, the Caspian Sea is not just some abstract point on a map. It's actually something we care about, and it's a snapshot of what's actually happening in the world and how all those environmental issues they just collide in one same place. So yeah, so one last message that I wanted to deliver today is that we can still save the Caspian, but only if transparency and accountability become the norm and not the exception. And thank you very much. I'm sorry.
What just one presentation? 4 or 5 minutes. I'll start. We should first announce my presentation. Yes, thank you, Martin. As Dina already told you, that's one of the goals of our campaign is to demand from the government and corporation accountability for pollution and destruction of the Caspian Sea. And she already mentioned that for the oil development of 3 largest oil fields in the Caspian region, namely Karachaganak, Kashagan, and Tengiz, the important documents are production sharing agreements. They were signed in the 1990s between the government and oil corporations, and they are kept in Kazakhstan as confidential information. That's why on January 14, I made a request to the Ministry of Energy for environmental information contained in all 3 production sharing agreements, as well as to disclose this information for the public. My request was based on Article 4 and Article 5 provisions of the Aarhus Convention in conjunction with the Article 2, Paragraph 3 of the Convention, providing the definition of environmental information. I was denied access to environmental information on and one of the reasons used by the Ministry of Energy for the denial was that the requested information shall be kept confidential in the interest of a third party. The third party in this case is oil companies. On 14 February, I appealed the denial of environmental information in the Administrative Court of Astana. The lawsuit was dismissed by the court, and the conclusions were made by the judge that the relationships between me and the Ministry of Energy on the request and denial of information weren't the public ones. It was also concluded that the information provided to me was just an information, and that denial was not an administrative act, and therefore it could not be appealed before the court. The conclusions of the court of the first instance have been supported by the courts of appeal and cassation instances. No legal remedies were available for me in Kazakhstan, and that is why I made a submission to the special procedures of the UN Human Rights Council and a communication to the Compliance Committee of the Aarhus Convention. Both submissions were made in October. I'm still waiting for the decision on the admissibility of the cases. I should mention that in case of the violation of access to information, the requested information is an environmental information falling under the definition of agreements on environmental protection or measures on environmental protections. There are no applicable exemptions from to restrict my access to this information, and I requested the right party. And in case of the access to justice under Article 9, the administrative court was a right instance to appeal the denial of access to information, and this is the obligation of the parties to provide access to justice in relation to access to information, including the cases where the access to information was denied by the requested public authority. I used also the special procedures of the Human Rights Council, but because in this case, the information is important not only for environmental public of Kazakhstan, because it's about transparency, and that is why it was important also to invoke submissions concerning the freedom of expression and access to justice. We have the legislation on access to justice, but in this case, the public authority, the Ministry of Justice, and the court were not able and were ready to apply the national environmental law and the Aarhus Convention. That is briefly my case. Thank you very much. I will be glad to answer your question. It will be time to answer them.
Yeah, thank you very much, Gina and Vadim, for a very interesting example of amazing activity for the Caspian Sea. So I hope it will help. Unfortunately, we need to free the room now because there's another meeting starting 5 minutes ago. So thank you very much for your participation. I apologize to online participants that they couldn't ask any questions. I hope coming.
Never happened.
I was wondering, like, when they would have. But people have signed up to it. Some have signed up to it. They're not.